CRS 242112 24211. CRS, this is Colorado law, common law of England. The common law of England, so far as the same is applicable and of a general nature, and all acts and statutes of the British Parliament made in aid of or to supply the defects of the common law prior to the 4th year of James the First, except in the 2nd section of the 6th chapter of the 43rd Elizabeth, the 8th chapter of the 13th Elizabeth, and the 9th chapter of the 37th Henry VIII, in which are of a general nature and not local to that kingdom, shall be the rule of decision and shall be considered as of full force until repealed by legislative authority. Interesting. So that means in Colorado there is common law. But then in the criminal code it says that there's no common law in the criminal code. But there is common law marriage. So it seems as though Colorado is a bit schizophrenic when it comes to common law. Now, common law, what it means, let me tell you what I just read. What I just read was a bunch of fucking horse shit. But they're saying all these old ass, fucking monarchs. So again, they don't care about the prime minister, the president. It's all about the king and the fucking queen. And fuck a king and queen. Who gives a fuck about a king and queen? A president, they got the support of the people. A king is just some asshole that, got born to the right family. Fuck you. That is just, you gotta earn your keep, okay? You wanna lead this damn nation? Convince us why you think you should lead the nation. If you can't convince us why you think you should lead the nation, I don't think you'll be strong or smart or good enough to lead the nation. Democracy's the only fucking way. So with this common law, this is the specific law of England. When people talk about common law, the common law. Most of you assholes, I've heard people talk about, they don't even know what the fuck they're talking, but this is what they're talking about. So you take all these laws from the James the First, Elizabeth the 13th, 43rd, and the 13th. How many Elizabeths? And then Henry VIII? Okay, whatever. They're just saying take all these kings and queens and then take all their judicial decisions and put them together. And then the common law was the law of the land in England that the commoners could understand. So therefore the judges could, depart with fucking dispense with judging. Here is the common law. We all got to follow the common law. And so the judges were on the same page. The people were on the same page. The common law comes from the case law of ancient England. Okay? That's important because we don't actually have common law here in America. And we got a constitution. So, fuck common law. Fuck the common law of England. Now, a common law, just that word by itself, means a law that every person, the little man, the small man, the, citizen, the American citizen, a common law for every American citizen, and for the politicians, a common law for us all, have, not the 10 Commandments, but an American 10 Commandments. If we had an American 10 Commandments and it was simple and everybody could understand it, here is the law. And, the simplicity is so fucking important. You don't want it to be so simple that it's innocuous and it's too vague and it doesn't. But you want it to be simple that everybody can understand. It's simple enough so that everybody can understand. That's common law. That's common law. So actually, technically, the 10 Commandments is common law. The 10 Commandments is common law. And in fact, I would actually say, put the 10 Commandments up against the common law of England. I believe more in the 10 Commandments. Thou shalt not steal, thou shalt not kill. And then, you shouldn't be stealing each other's fucking spouses and shit. So there's actually some common sense there. I don't really know what all that body of law, the common law of England, we also don't need it. We got our own case law. We have all of our own judicial systems, our own Supreme Court, and, local, and we have an American, we've been around so it just doesn't make any sense for us to hold on to this ancient So we should form our own common law. And this shit, this is I did a LexisNexis. This is all about the 1906 Attorney General of Colorado versus Times, News Times Publishing Company, which is actually the Denver Times and the Rocky Mountain News, something like that. There's two daily papers in Denver that is up against the Attorney General of Colorado, and the Attorney General of Colorado is like, hey, you can't make fun of me and the News Times Publishing Company. This is a 1906 Supreme Court Colorado decision. Like, yeah, we can, bro. Bro, we can make fun of you, you know? Like, that's America and shit. Like, what do you... So LexisNexis, they go ahead and say that the Attorney General v. News Times Publishing Company, we learn a lot about common law. So here's what we learn about. This is good law in Colorado today. Because LexisNexis took the Attorney General News Times Publishing Company and said, here's a principle that we can use today from that case. So I'm just going to read all the principles, and then there's some more I'm going to read, and then I'll talk some more, and then read, and then conclude with a big old funny joke. A big old fat funny fucking joke, okay? Why the original 13 states took the common law by inheritance and so held it at the time of the adoption of their constitutions, Colorado took it by legislative enactment and so held it at the time of the adoption of the Colorado Constitution. Interesting. So they're saying that the legislative at the time in the Constitution, so basically both the Constitutional Convention and the legislative, body says, hey, we got common law, so that's why it's there. That's not just the Attorney General versus News Times Publishing Company, 1906, but that's also Ayer v. Johnson, 1888, Chilcott v. Hart, 1896, Teller v. Hill, 1903. There's an appeal that was dismissed, so that's interesting. 1906, People ex rel. Attorney General v. News Times, and that's there's an appeal that was dismissed in that case. And then Votes v. Garrett, the 1960 decision, VOGTS v. GUERRETTE. When the courts of the original 13 states came into existence by constitutional creation, they took common law powers by reason of the presence of the common law in their respective jurisdictions. So they're saying that common law was in the original 13 states. They're in the English colonies. Before America became America, the British English redcoats were a bunch of common law, loving sons of botches. And the original 13 states took common law by inheritance, just to repeat, to reiterate, to reinforce, and so held it at the time of the adoption of their constitutions. Colorado took it by legislative enactment and so held it at the time of the adoption of the Colorado Constitution. So not by inheritance, right? They're saying that Colorado was basically born with it. When Colorado was born in 1876, common law, so there's a Colorado common law. And I don't think that's defined at all. And then they're saying that the reason why the 13 states were able to adopt common law was because there was common law in their jurisdictions already. So common law was being practiced amongst their judges and people already. And so they were just kind of codifying, they were etching in stone a routine, an institution that was already in place, that was already a part of the system. When the courts of Colorado came into existence by constitutional creation, they took common law powers except where the Constitution otherwise provided. And so that's actually, the way I understand common law right now is that it's undefined. Common law married, there's something about common law marriage. But most of the time, the criminal code rejects common law, so common law doesn't come up much. But they were going after the home rule, the 20th Amendment. So this was actually a lot of issues comes out of this case. The Attorney General of Colorado versus the News Times Publishing Company. I wish they would have gone with Rocky Mountain News or the Denver Times, because Times News, that's the corporation that owned the... So the Attorney General versus the Rocky Mountain newspaper, because they are daily newspapers. This is a media a press, freedom of the press issue versus the government's, I don't know, privilege fucking of not, nobody can, you can't make fun of me. Hey, mister, don't make fun of me. You ain't allowed to call me an asshole. No, you can't call me a piece of shit. I'll show you for calling. You want to call me a piece of shit? I'll show you. You called me a piece of shit on the internet. You blogged that I was a piece of shit. Well, I'll show you who's a piece of shit. You piece of shit. Therefore, the Supreme Court of Colorado is a constitutional court with common law powers. Wow. That was a big fucking jump. Okay, so basically that's why they're just kind of putting all that together. Also because it's within the power of the General Assembly to take away any power not expressly granted by the Constitution. There you go. It's in the Constitution. It's saying that the General Assembly cannot take away any power not expressly granted in the Constitution. So that means natural laws are good too. We have all the constitutional freedoms and natural freedoms. That's protected in the Constitution as well. But this is saying that the General Assembly could have got rid of the common law. So if the common law of England was something that the General Assembly wanted to get rid of, they could have gotten rid of. They didn't get rid of it. So therefore, it's kind of sitting there. It's dangling. And I don't know of any experts of the old ancient English common law. But, perhaps we could really get into the nitty gritty because a lot of this shit is just, it's kind of confusing, isn't it? The common law prior to the 4th year of James I. James I, that's King James of the King James Bible, right? That's Mary Queen of Scots' son, right? Mary Queen of Scots' son is James I. And then Henry VIII is the one that keeps on chopping all of his wife's heads. So we're going to listen to the judicial that's the bookends, right? They're saying, okay, you got James I, and then from Henry to VIII to Henry to James I and then what's the 6th chapter, the 43rd Elizabeth? You got the 2nd Elizabeth, 3rd Elizabeth. What, she named the law after herself? Or are we talking about two different Elizabeth monarchs? The 8th chapter, the 13th Elizabeth? The fuck are you talking about? The laws Elizabeth? I don't understand specifically except in the 2nd section of the 6th chapter, the 43rd Elizabeth, and the 8th chapter, the 13th Elizabeth. What the fuck are you talking about? Now, I understand Henry VIII, James I, Elizabeth, you got Queen Elizabeth first and second, but I don't know if they're talking about the monarch. They are talking about the monarch and it's a body of law. So it's take 500 years. I'm just kind of throwing out a number, but just to give you a sense, ancient England, 500 years, all the common law that came out of that 500 years. That we determine today in 2022. That's common law. That is common law. So, what do we learn from LexisNexis? Colorado's legislative branch hasn't taken the common law away, so the old ancient English common law is still there. The Supreme Court of Colorado is a constitutional court. And they have common law powers. What the fuck common law powers are they adding in additional to? They have absolute pretty much authority anyways. What common law powers? They just want to take more authority, right? Isn't that what the 3 branches are supposed to jealously guard their authority? So that's just the judicial branch saying, no, not only do we have a right to judicial review, but we also get all the powers that the common law gives us too. When the courts of Colorado came into existence by constitutional creation, they took common law powers except where the Constitution otherwise provided. Now that's interesting. They're saying basically the original courts of Colorado began with the common law powers except where the Constitution otherwise provided. So they were actually going with the English common law, and then they said, oh, and by the way, Colorado's Constitution says this. So that sounds so fucking backwards to me. It's Colorado's Constitution says this, and then every once in a while the ancient English common law might pop up. The Common law marriage is if you've been living together for 5 years, 7 years, 20 years, then you're common law married, meaning you weren't married by the state or any, so-called authority, but just the nature of you living together for your entire lives, you all were married. You loved each other. In fact, that's actually probably a common law marriage. There's actually people can apply for common law marriage, which is fucking crazy. If you're common law married, that means it's actually more powerful, I think, without this certificate, without the thing, because you're just together to be together. There's no financial, fucking togetherness or whatever. You just like each other's company. So in a way, common law marriage seems like the best goddamn marriage ever. So the Denver Times and the Rocky Mountain newspaper, 1906. Colorado case law, Colorado Supreme Court decision, 1906. Attorney General of Colorado versus the News Times Publishing Company. There was actually some weird. They had like the Attorney General, but they had like some weird something right before it. I don't know. I shortened it to just Attorney General and then added the Colorado part because it's the government versus the newspaper. It's the head law interpreter, law enforcer, the Attorney General versus the newspaper. So if we're allowed to insult and shit and make fun of and criticize the Attorney General, which clearly we are as Americans, I can criticize my government. I can write a newspaper, I can write a blog, I can write on this little piece of paper and give it to old JoJo Beans down the street and say, hey, that damn Attorney General, he's a pile of shit, you know that, right? So N.C. Miller, his shit, stinks just like the rest of us. N.C. Miller's got to put his pants on one leg at a time just like the rest of us. N.C. Miller, he gets his cake and he eats it too just like the rest of us. So what's my point? My point is I was going to read this entire case into the record. Do I want to do that? I don't want to read all this. I'll just, let's go down here to just some of the highlighted things. The elections decision. The decision rendered yesterday by a majority. This is from the Supreme Court case. I'm just reading directly from it. The decision rendered yesterday by a majority of the Supreme Court in the election cases is the most far-reaching and portentous that has ever been rendered by any court in the United States. For the first time, the provisions of the 20th article are the latest expressions of the sovereign will of the people. The Supreme Court holds that portions of it are inoperative because they're unconstitutional. That's another thing. The Home Rule Amendment says that cities and towns and villages have the ultimate authority and ultimate power in Colorado. We got 100 Home Rule cities, including Sanford and Alamosa, and I want to say Monte Vista, I'm not for sure, but they should be if they're not. In other words, a part of the state constitution is unconstitutional, treating constitutional provisions as though they were state statutes and subject to be annulled by measuring them with the constitution of which they are a part. The wrongs that this decision will work are innumerable and irreparable. The chief scheme of government under the 20th Amendment, the consolidation of offices, the retrenchment in salaries, home rule, and local matters are all practically wiped out, and the old and pernicious order of the things restored. The people of St. Louis and San Francisco, who've been enjoying the full benefits of just such a system of government as the 20th Amendment provides, Home Rule Authority, will be astonished to learn that they no longer live in a republic. For the Colorado Supreme Court holds that such a government is so unrepublican that it cannot be tolerated in Colorado. What's next? If somebody will let us know what next, the utility corporations of Denver and the political machine they control will demand the question will be answered. Utility corporations. What? You're saying we're puppets? We're just puppets to the electric company? We're not just puppets to the electric company. We're bigger than that. We're not just puppets to the utility with the sewage, water, and electric. No sirree, Bob. That the concluding paragraph of said editorial article is as follows. What next? If somebody will let us know what next, the utility corporations of Denver and the political machine they control will demand the question will be answered, meaning thereby that this court and the justices thereof are controlled by certain corporations and by partisan political influence, and we're so controlled in rendering the decision in said causes. The Attorney General further gives the court to understand and be informed that on the 25th day of June A.D. 1905, there appeared on the first page of the Rocky Mountain News, one of said newspapers so published as aforesaid, a certain cartoon and illustration wherein are shown characters of 5 members of this court, namely Chief Justice Gabbert, Mr. Justice Maxwell, Mr. Justice Bailey, Mr. Justice Campbell, and Mr. Justice Goddard, and wherein Chief Justice Gabbert is represented as the Lord High Executioner in the act of beheading certain persons described therein, being the incumbents of certain county offices and litigants mentioned in the foregoing causes pending in the court. In this court, with display headlines in large letters over said cartoon and illustration, reading as follows, namely, if the Republican Party has overlooked anything from the Supreme Court, it will now proceed to ask for it. Also, the following words appeared therein as described in the court, namely, the great judicial slaughterhouse and mausoleum, thereby meaning and intending to convey the impression to the public that this court and the several members thereof, and especially Chief Justice Gabbert, Mr. Justice Maxwell, Mr. Justice Bailey, Mr. Justice Campbell, and Mr. Justice Goddard were and are influenced by and were and under the control of the Republican Party and were and are governed by political prejudice, and that this court is under the domination of a partisan political machine and of certain political bosses, and were at the time of rendering said decisions are at the present time so influenced, controlled, governed, and documented and dominated, probably documented, that the said cartoon and the accompanying headlines as published in said newspaper are attached hereto as a part hereto and are as follows. Thereby that undue influences were brought to bear in appointing certain judges of said court. And I am old and experienced enough to judge of motives, and knowing the sponsors of the Chief Justice, meaning Chief Justice Gabbert, and his colleague Goddard, meaning Mr. Justice Goddard, and the interests they control, I'm convinced that their intervention after the last election to overturn the Senate as it stood and to bowl out Governor Adams was not merely to prove themselves powerful bosses, but to advance themselves politically. But it was to carry out a business proposition. That means millions upon millions to them, and especially to William G. Evans, the most conscienceless boss that ever bestowed a suffering people, meaning that Chief Justice Gabbert and Mr. Justice Goddard were under the control, directly or indirectly, through third persons of William G. Evans. That bitch-ass pile of shit. That bitch-ass schmegma dick fucking... That shithead dickhead, dickhead shit dickhead, for the purpose of carrying out that schmegma infested dickhead, for the purpose of carrying out certain business propositions which would bring millions upon millions of dollars to said third person unnamed, and especially to William G. Evans. They find the Denver Charter in their way, the clauses that under the Rush Amendment prohibited the granting or renewal of franchises is an obstacle to the renewals both Evans and Cheeseman must soon have, or the vision of Denver, continuing their lawful prey for half a century, will vanish as the morning mist. Their activity to secure a